Hey now, we are back. Next section. All right, this is for MBE students only. JD students, be warned. This is in some ways a very cursory review geared towards the bar exam. And additionally, I can't even cover everything in the sufficient detail because we just have limited time. So I'm picking and choosing. You have been warned. All right, our next topic is joinder. Now, the first caveat that I'll give you is joinder is not the same as subject matter jurisdiction. All right? Even if joinder is satisfied, you still have to analyze subject matter separately. And even if subject matter would exist, that doesn't mean joinder was appropriate. All right, so just be really clear on that. So let's talk in a real basic way regarding joinder. With joinder, you'll need to analyze each claimant party separately to make sure the joinder is appropriate. Now first, we have Rule 13, right? Claim and counterclaim. Counterclaim would be compulsory or permissive. So P sues D for negligence, and the defendant counterclaims for negligence arising from the same car accident. Is that going to be permissive or compulsory? Compulsory. All right. A compulsory counterclaim is one that arises from the same transaction or occurrence as the opposing claim. It's one that's ripe, which means it exists at the time the defendant serves the answer. It's not pending in another litigation, so it hasn't already been asserted somewhere else, and does not the plaintiff's claim is not solely based on attachment. You know, think like in rem or quasi in rem jurisdiction. All right. Technically, for a claim, or technically for a counterclaim to be compulsory, all of these have to be satisfied. All right. But let's be honest. You know, the one thing that they're likely to test you on in the bar exam is TRO. That's going to be the biggie. That's the one that if you don't know it, you're likely to screw up. Transaction or occurrence. All right, so we're looking at things we've talked about before in other contexts, right? Is it the same? We're comparing one thing to another, claim to counterclaim. We're looking to evidence, timing, logical relationship, things like this. All right. So that's a 13A compulsory counterclaim. Means you must assert it, and if you don't, you risk being precluded later on from asserting it. 13B is a permissive counterclaim, which may be brought but need not be brought. A permissive counterclaim is defined simply as something that's not compulsory. It's a counterclaim that's not compulsory. You know, either it's not the same TRO, or even if it is the same TRO, the claim's already been asserted elsewhere, right? And the defendant is choosing to assert it even though it doesn't have to. All right, moving on. Crossclaims. Crossclaim is a claim between co-parties. So plaintiff sues D1 and D2 for negligence for a 3-car accident. Okay? Well, defendant 1 can sue defendant 2 by way of crossclaim. For instance, in this 3-car accident, suppose defendant 1 wants to sue defendant 2 for negligence, right? That would be a permissible crossclaim. Now, the rule for crossclaim requires that a crossclaim arises from the same transaction or occurrence as an original claim or a counterclaim. All right? Well, if it's a 3-car accident, boom, 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 and these guys are being sued for negligence, and now the first defendant wants to claim against the second defendant by way of crossclaim, that would be fine. You know, as long as there's subject matter jurisdiction, which again is a separate consideration. However, what if defendant 1 wants to crossclaim against defendant 2 for an unrelated breach of contract? Is that a permissible crossclaim? The answer is no, because this unrelated breach of contract does not arise from the same T or O as the original claim. However, now we should think about Rule 18A, which tells us once we have a proper claim, counterclaim, cross-claim, or third-party claim, we can pile it on. Once you have one of these valid things over here, you can bring up any additional claims you have against the opposing party, even if they're unrelated. So suppose D1 cross-claims against D2 for negligence. Well, pile it on. So now D1 can assert an additional claim for breach of contract. Why? Because we have an appropriate valid cross-claim, and now the defendant can bring in additional claims against the opposing party, even if they are unrelated. Okay? Good. Let's move on. Let's talk next about Rule 14. Rule 14 is known by a couple names. One is impleader. Okay, impleader. More better known, easier to remember, is third-party practice, third-party claim. And so that's when you have a scenario like this. Plaintiff versus defendant. Plaintiff sues defendant. And defendant says, hey, there's this other person out there who's a non-party. All right? And I think that non-party owes me money if I owe money to the plaintiff. So here's Bob over here. And say the defendant thinks, hey, Bob, if the plaintiff wins and I owe money to the plaintiff, then Bob, you owe money to me. For example, suppose there's a contract of indemnification between Bob and defendant. Suppose Bob hires defendant to drive his car from Florida to Alaska and says, don't worry, if anything bad happens, I got you covered. All right? Well, let's just assume, for the hypo, that that's an enforceable contract of indemnity. Okay? Well, defendant brings in Bob and says, Bob, and here's the technical language, Bob, you are or may be liable to me for all or part of the claim against me. So note here, the liability of Bob is not to the plaintiff. The liability of Bob is to the defendant. Okay? Here's another example where third-party practice would be appropriate. Sally, say there's a 3-car wreck and plaintiff sues defendant. Okay? And for some reason, the plaintiff didn't assert a claim against Sally. And the defendant thinking, well, it's ridiculous. Sally wasn't joined. I'm going to drag her into this lawsuit against her will as a third-party defendant. And I'm going to seek contribution against her. You guys covered contribution in torts class, I would assume, right? So contribution is saying, hey, even if I'm a tortfeasor, there's other people that are jointly and severally liable along with me. I could sue them later on by way of contribution, but let's just drag them into the lawsuit and get contribution from them now, so I don't have to pay money and then try to recoup it later on in a separate lawsuit. So what defendant's saying to Sally is, hey, Sally, you're another driver in this accident. You're a co-tortfeasor. So if I'm liable to the plaintiff, well, then you're liable to me by way of contribution, right? That's impleader. That's third-party practice. Right? Now the rules allow claims like this to get much more complicated. So for example, defendant could then add a second claim under Rule 18 for an unrelated breach of contract, right? Because of Rule 18, because we have a proper third-party claim, right? Or the plaintiff could sue Sally, because Rule 14a3 says the plaintiff can assert a claim against the third-party defendant so long as this claim arises from the same transaction or occurrence as the original claim, right? For her part, Sally could implead another person, let's call that person Ted, as a fourth-party defendant. Say there's an indemnification agreement between Sally and Ted. So, things like cross-claims and impleader are examples of how lawsuits can become very complex very quickly, right? And indeed, the federal courts have powers under a variety of rules, including Rule 42, to have separate trial on various claims, if it's going to be too confusing to have all this stuff, tried together. Bless you. All right, let's keep moving. Let's see, we're at 6 o'clock. 14 we've done. Rule 20, do real quick. Rule 20 is permissive joinder of plaintiffs or defendants. So under Rule 20, you could have multiple P's against one D. You could have one P and multiple D's. you could have multiple P's and multiple D's. Sounds like a disease. All right, under Rule 20. And the standard there requires there be at least one question of law or fact common to all of the joined parties. Okay. In addition, that the claims arise from the same transactions, occurrence, or series of transactions and occurrences. So we have another variant of our TRO formulation here. Okay, but this is permissive joinder. That means, for example, in this scenario, these plaintiffs could join together against the defendant, or they could pursue their own federal separate lawsuits. In fact, think of it, the Star-Kissed Tuna case, right? Little girl slices her hand, right? And then she sues, her mom sues, her dad sues, I think one of the siblings sued. Well, that's Rule 20 joinder. It's permissive. These plaintiffs could sue separately against Star-Kissed Tuna if they wanted to. They didn't have to, but they chose to sue together. And indeed, it made good trial strategy for them to sue together. Now let's compare Rule 20 joinder to Rule 19. Rule 19 is required joinder. And I'm going to give somewhat of a cursory discussion of Rule 19, because Rule 19 is quite convoluted. So I'm going to take kind of the big picture approach to Rule 19. How the rule actually functions, okay, on the big picture, the purposes of each part. And then in your bar review, then you can dig deeper into the rule. And if you have any questions, I'm going to be teaching this summer in June, okay, or I'm available by email. Come on by my office, hang out. You're a former student, we get to see each other. If I haven't had you as a student before, then we get to hang out and I get to meet you. All right? So just hunt me down, no big. But here's the basic operations of Rule 19. I call Rule 19 the VIP rule. If a lawsuit's a party, then the VIP rule says there's somebody that hasn't been invited to the party, but they're so important that you have to invite them. And if they can't come, you have to decide whether or not to cancel the whole party. That's the kind of purpose, the idea behind Rule 19. So under 19A, you got to ask two questions. All right. First question is the absent person required to be joined? All right. Are they required to be joined? If the answer is no, then that's the end of the analysis. Okay. And I can't go into more detail on that. The rule gives 3 examples of when a joinder is required to be joined. And we only have 25 minutes left, and I won't be able to cover it. But just one example would be the absent, that the present party faces multiple liability, right? So you sue me, but if we don't join another person, then I could end up being liable twice for the same thing, right? So that means we need to get in the person that's not there, to whom I might also be liable, right? It's about that kind of idea of fairness, the litigation, the kind of due process ideas we're talking about in a separate section of our review. Well, if they're not required, that's the end of the analysis. If the answer is yes, then you have to ask, you continue, you say, is joinder of the absent person feasible? Okay? Feasible means that joining them won't destroy diversity, that there'll be subject matter jurisdiction over them, that there'd be PJ over them, it wouldn't mess up venue, okay? Those are examples of where feasibility is triggered. Well, suppose somebody's required to be joined, but joinder, well, let's see, if a joinder is feasible, it won't mess up PJ or anything, then the court has to join them, right? Join the absent person. But what if the answer is no? For example, there wouldn't be PJ over the absent person, right? Well, everything up to this point, the feasibility analysis, that's all 19A. Is the person required? Are they a VIP, right? If they're required and they're a VIP, then you join them if feasible. In other words, invite them, right? In other words, require them to be in the party. The court actually then joins that person. The person doesn't have a choice. If you're required and joinder is feasible, court joins you. It enters an order joining you. And guess what? Boo-hoo, you're joined whether you want to be there or not. Well, if joinder is feasible, yes, then the court joins them. But what if joinder is not feasible? Okay, they're required. They can't be joined. Joinder's not feasible. Now we're in 19B territory. And now the question is, keep the lawsuit as it is, or dismiss the civil action. All right? And in 19B, the rule gives 4 factors for the court to use in equity, in other words, in discretion, to determine whether or not to proceed without the absent person or to just dismiss the entire civil action, right? So there's a bunch of factors looking to prejudice to existing parties and absent persons, the possibility of shaping the relief so that it's not going to hurt people, the availability of an alternative forum if the action is dismissed for non-joinder, and so on and so forth. So that's as much detail as I'm going to get into, because the clock is ticking. See what else is worth going into. A couple moments on Interpleader, a couple moments on class actions, and then we move on to another topic. Now, Interpleader is different from impleader. Impleader is third-party practice under Rule 14. I don't have a marker on my forehead, do I?
No.
Oh, okay. Not there would be anything wrong with that, but it's got it all over my hands, and then I touch my head. Not going to be on YouTube like that. Okay. All right. Interpleader is 2 types. Rule 22, that's called Rule Interpleader, and 28 U.S.C. 1335, that's statutory interpleader. Okay. Real basic stuff here. Interpleader means there is a stake. It's property. There is a stake. That property might be a thing like a bottle of water. It's the magical bottle of water. It's worth lots of money. Or it might be money. Or it might be an insurance policy, right? It might be a house. Some sort of property interest. And the stake is held by the stakeholder. So, for example, here's Nathenson. And he finds this nifty iPad. Oh, this is so nice. It's not mine. It's nice. Turn it on and I see it's locked, so there's nothing I can do. I don't know whose it is. I think, well, if I could open it, I could figure out who it is and I'd give it to them, but I'd probably feel really uncomfortable about opening someone else's iPad. But you get the idea. Like, I don't know who it belongs to. All right? And I think, wow, I'd really like to return this to whoever owns it. And then here's 2 people that say, oh, that's my iPad, Professor Nathenson. No, it's my iPad. No, it's mine. It's mine. I'm like, what do I do? What do I do? Right? Well, we have multiple claimants here, right? We have 2 claimants, each of whom are vying for possession of the iPad. We're like, well, if I give it to you, you might sue me. If I give it to you, you might sue me, right? Or even if you sue me and you win, I can still get sued by you, second claimant, and face a second judgment. I could face inconsistent liabilities. Get sued by 2 people, both of whom claim they own the iPad, and I get 2 separate courts telling me to surrender the iPad, right? Well, that's a problem. Interpleader is the solution to that problem. So what I can do is, if I am a stakeholder facing claims from 1 or more claimants to the stake, I can interplead them both. So here we have the stakeholder. It's going to interplead claimant 1 and claimant 2. All right? And now I say to the court, hey, Your Honor, here you go. Take the iPad, make them interplead amongst themselves, and then the court decides who this belongs to. Right? And then I wash my hands of it. Right? And now I don't face inconsistent or multiple liability. It also comes up in insurance scenarios, right? You have, let's say, like $1 million cap on the policy, but you have $10 million worth of claims asserted against it, right? So in the State Farm versus Tashire case, that was an interpleader case involving an insurance claim, right? Insurance fund. Okay. Now, with these 2 flavors of interpleader, there are some important differences. And here I'm going to make you do the homework. There's a handout on my website. You go to the resources page, nathenson.org, nathenson.org, courses, CivPro, study materials, Joinder, and then there's a page that has a nice table on statutory versus rule interpleader. Basic difference is rule interpleader uses normal rules of PJ, subject matter jurisdiction and venue that we talked about earlier and that are on separate videos. With statutory interpleader, we have superpowered forms of PJ, subject matter, and venue. Okay? So for example, PJ is nationwide as long as the claimant is sued in any judicial district, served in any judicial district. Subject matter jurisdiction is minimal diversity between claimants and amount in controversy of 500 or more. So it's really easy to meet this standard. And then there's a specialized venue statute, and I'm not going to get into that right now. But just as a very brief illustration of how powerful statutory interpleader is suppose you have a citizen of Florida sue a citizen of Florida, and Alaska, okay? Boom, 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 for a trombone worth $500. And defendant 1, 2, 3, and 4 are all claiming the trombone is theirs. Well, under the normal rules of diversity, the amount of controversy would be too low, and then we'd lack complete diversity, right? But under statutory interpleader, amount of controversy needs only be at least $500, not more than 500, but 500 or more. And you need minimal diversity as measured between the claimants. So even though we have multiple Florida claimants, it's okay because you have at least one claimant that's diverse from at least one other claimant. So it's really easy to satisfy 1335 subject matter jurisdiction. There's ways to satisfy this one, but not that one, but I'm not going to get into that. That's just a level of detail. If you're curious, come and see me and I'll give you some additional hypos. So that's interpleader. Now finally, class actions. I really just don't have time to get into it in any level of detail. I'll just note some things that I want you to follow up on, so I'll give you some homework. All right. First is 23A, all right, are the prerequisites. You've got to make sure you have numerosity, commonality, typicality, and adequate representation. All right? There's no magic number for numerosity. Less than 20 people in the class is probably too little. Probably more than 100 is going to probably be enough, right? But it's just so numerous that it's class actions better than normal joinder under, say, Rule 20. Typicality means the claims of the class representative is typical of the claims of the class, right? Commonality means that questions of there's at least one question of law or fact that's common to all the class members. Let me take a peek. Brain's starting to get tired and I don't want to get this one wrong. Here we go. Yeah, I was right. There are questions of law or fact common to the class. And then finally, that the class representative is going to give fair and adequate representation to the class. Well, those are just the prerequisite. If these things are met, then we go into Rule 23B, which are the types of class actions. Okay, and this is a level of detail, again, that I don't have time to get into. So I'll focus on just two of them very briefly. A 23B2 is typically used for claims for equitable claims or declaratory judgments. All right? For example, you're suing a school district to have them change how they do a particular policy, and you want injunctive relief against the school district, or like civil rights claims, okay? That's typically going to be a 23B2 class action. A 23B3 class action is typically going to be what you use when you're seeking monetary relief. For example, like a products liability claim, right? Or consumer fraud or something like that. Or like when you see telephone companies getting sued. For example, the Twombly complaint was originally filed was a putative class action on behalf of most of the consumers of telephones in the United States, or something like that. And it's much harder to get certification of a 23B3 class action because the class representative has to show that a class action is superior to other forms of litigation, such as Rule 20 joinder or separate lawsuits, right? And that the common questions of law or fact predominate over individual issues. So, for example, you might have a predominance question if, say, you have a toxic tort case, right? And the individual questions of causality and damages are, say, they hypothetically differ significantly, right? Well, the court in 23b3 regarding predominance is going to ask, would the common questions of liability in terms of the bad stuff that the defendant did, do those predominate over individual questions like the individual damages or the individual causation, things like that? Okay, beyond that, on class actions, there's a gazillion issues I could talk about and unfortunately just lack the time. For example, the court gets to decide whether the class is certified or not, right? The court gets to decide whether or not there's a settlement for a certified class, and they have a certification hearing. The court gets to decide who the class counsel is going to be. So if you're the class rep and you have a lawyer, that doesn't mean your lawyer is going to be the class counsel. It's for the court to decide who the class counsel is going to be. Last thing to note on this is with 23b3 class actions, there's additional hurdles that make these things hard to prosecute, which is you have to provide notice to members of the class, something that's not necessarily required otherwise in other types of class action, and class members have the right to opt out of the class action and proceed with their claims individually. All right, now I'm going to pause the camera now. Thank you.